Hi, everybody. My name is Dwayne Bratt. I'm a political science professor at Mount Royal University. This is the second video mini lecture to help you prepare for the forthcoming WTO simulation on the environment and trade. The first video mini lecture was done by Chris Kikucha, who looked at how the environment is identified in various WTO GATT treaties and documents, as well as regional trade organizations too. The purpose of today's video mini lecture is to show how that tension between the environment and trade has played itself out in the WTO by looking at two cases that were adjudicated by the WTO dispute settlement mechanism. Just get my presentation up here. Okay. So just to reiterate what Chris had done, the WTO is concerned about the environment, and there are a series of provisions in numerous WTO treaties. There's even a WTO Committee on Trade and the Environment. But we have to recognize that governments are very good at protecting trade, and they can use very sophisticated means, including using environmental protection, which is really a ruse for trade protection. The WTO recognizes that states have the ability of unilaterally implementing environmental regulations. It is an important prerogative of government, but they can't be used to discriminate against foreign imports when no real environmental benefit can be discerned or demonstrated. So let's look at the two cases. The first case is the reformulated gasoline case, also called the U.S. Clean Air Act case. And I have included the link to the actual decision of the WTO in my slides, and this was launched by Venezuela and Brazil against the United States. The second case involves shrimp and turtle. There were actually two cases. The first one between India, Pakistan, Malaysia, Thailand versus the United States, and the second one was just Malaysia versus the United States. So let's look at the first case, the U.S. Clean Air Act case. This is important for a number of reasons. First, it was the first case decided by the WTO. The WTO was launched in 1995, and by 1996, early in 1996, they had issued their first ruling. And it was agreements, as I mentioned, coming from Venezuela and Brazil. What they were upset about was a provision in the 1990 United States Clean Air Act, which discriminated against their gasoline exports to the United States. Under Environmental Protection Agency regulations, gas companies had to produce the same quality of gas that they produced in 1990. But every company was given a different baseline because every company produces a different kind or quality of gasoline, if you think about leaded or diesel gasoline. So determining that baseline for American companies, that was pretty easy to do when they could verify it. But dealing with foreign companies, that was much tougher. So the EPA took a shortcut. And this shortcut would end up biting them later on, where they assigned one baseline for all foreign companies, and that baseline was an average of the American domestic producers. Venezuela and Brazil claimed that the baseline was too high and was discriminatory. They said that instead, foreign companies should be treated the same way as American companies. Basically national treatment, an important principle in trade law, not an average. The Americans argued that its domestic producers would face unfair competition because foreign imports were of a cheaper quality, and as a result, the price would be cheaper. The WTO convened a panel of experts to review the case and ruled that the EPA did discriminate against imported gasoline. The United States appealed this ruling, but the appellate body upheld it a couple months later. This was a very important test. The WTO had just been created. It was the first case and involved the most powerful country. And it ruled against that powerful country, the United States. Yet the United States, instead of ignoring the ruling, complied with the ruling. Therefore, to look at how important this is, we're going to go back to a video mini lecture that Greg Anderson had done, looking at IR theories and their application to international trade. And so I'm going to explain the competing explanations of this case through the lens of four prominent IR trade theories. The first is realism. And what realism needs to do is to try to figure out why the United States abided by a ruling made by an international organization against its national interest. And it does so in several ways. It says that it wasn't a pressing security issue. It was about environment, it was about trade. And under realist perspectives, those take on lesser importance than security. It allowed the Americans to gain additional oil suppliers, and in fact, the Venezuelans and Brazilians imports to the United States increased after this ruling. It strengthened the WTO, which was an objective that the WTO, which the Americans had. They wanted a stronger WTO, and therefore, by abiding by the ruling, it made the WTO stronger. So a short-term pain for a long-term benefit. It could also blame the WTO for changing an environmental law. Many in Congress, both Republican but also Democrat, really didn't want these tougher regulations. And therefore, when the Clinton administration enacted these changes, they could blame the WTO for something that it was going to do anyway. So ultimately, realists conclude that the U.S. sacrificed little in complying with the WTO ruling, but gained a lot. What about liberals? Well, the liberal perspective is that the WTO ruling shows how important supranational institutions can have on settling trade disputes. And it shows that the WTO, by having a robust dispute settlement mechanism, was much stronger than the previous GATT. The WTO also confirmed what many trade experts had already said, that the regulation really did discriminate against Venezuelan and Brazilian exports. And the panel of experts determined that the regulation really wasn't crucial to environmental protection and air quality in the United States, that it really was disguised trade protectionism. Marxists have a very different view. It demonstrates that when there is a clash between the environment and free trade, trade wins, and that trying to reconcile the environment and trade is very difficult to do. The WTO prefers businesses over people, like oil companies, and laws designed to protect the environment, but also consumers and the people living with their air quality. And so businesses, free markets, free trade are all privileged at the cost of consumers, workers, and in this case, the environment. That the real beneficiaries of the WTO ruling are not Venezuela, are not Brazil, but the Venezuelan oil company, the Brazilian oil company, and in fact, all oil companies around the world. That existing environmental regulations, but also future environmental regulations, will always take a backseat when it comes to expanding international trade. The WTO rejected the argument that the EPA was trying to remove pollution from the air, And as a result, substandard gasoline could now be imported to the United States, while the EPA is deterred from changing those standards in the future. The feminist perspective shows that social causes are marginalized in the pursuit of free trade. While this specific case, the nullification of one regulation, does not have a direct effect on all women, it does show that the WTO trivializes issues that are important to women. And we do know that there is a large gender gap when it comes to environmental protection, with more women supporting it, more men believing that the economy matters more than the environment. They also note that if environmental regulations can be changed in the United States and other advanced economies, it's going to be even tougher to bring in environmental protection in less developed countries. They note that the female experience in the developing world is very different from the male experience, but also from Western women's experiences, because they are directly tied to the environment for their survival. In many cases, it's the women that have to drudge great distances for clean drinking water. Environmental degradation lowers the quality of life for women and children, and shows the masculine bias of the WTO's supposedly liberal orientation. So this is why this case needs to be looked at, because it was such an important case. It was the first case, and that's why viewing this case through multiple theoretical lenses is a real benefit. The second case we're going to look at is shrimp and turtles. And every time you see an anti-WTO demonstration, you'll see people dressed up as turtles. And it's to protest not just this case, but also the idea that the WTO discriminates when it comes to the environment. This has led to what has been called the Teamsters and Turtles Alliance in opposition to the WTO. The Teamsters refers to union members, the Turtles refers to environmentalists. In many cases, unions and environmentalists disagree on a lot of things, but what they do share in common is opposition to the WTO, albeit for very different reasons. So what was the shrimp and turtle case about? Well, before we look at the specifics of the case, we need to look at a precedent case from about 20 years prior. In the 1970s, GATT, which was the predecessor of the WTO, made two key rulings on tuna and dolphins. You may remember the old Star-Kissed commercials about tuna, and where they branded itself as dolphin-free tuna. Well, there was a lot of public pressure in the United States in the 1970s that would ensure that tunas were caught that didn't also get dolphins in the nets. And so to sell tuna in the US, they had to use special netting. These nets were new technology, but they were also expensive technology. And so there were critics who said that this really wasn't about protecting the tuna. This was about protecting American fishermen's jobs from, let's say, Mexican fishermen. And that's what happened. Mexico, as well as the European Economic Community, filed suit in the GATT against the United States, saying that the purpose was not to protect dolphins, but to protect U.S. fishermen. The U.S. lost both cases, and they lost both cases on very similar grounds. One was the idea of product versus process, and this will be explained more in this course, but briefly, it means that you can't discriminate on a product, let's say an apple or a chair, or in this case, tuna or shrimp, based on how it is made, the process that it is taken from a tree. Is it hand-picked? Do they use special technology? What sort of netting is used? Are chairs done in a craftsman or through robotics? You can't discriminate based on process, and the U.S. lost both rulings. Extraterritoriality is when you apply American law to other countries. So fast forward 2 decades, and we see a similar case playing itself out. A group of environmental organizations sued the U.S. Environmental Protection Agency to adopt procedures that would allow shrimp to be caught, but not endangered sea turtles. And as with the tuna case, this meant that shrimpers had to adopt new technology called turtle excluder devices, but this technology would be expensive. And so again, is this about protecting shrimp or about protecting American shrimper jobs as opposed to shrimpers in lesser developed countries? Malaysia, India, Pakistan, and Thailand got together and filed suit in the WTO opposing this requirement. And the initial decision of the panel of experts ruled against the US for the same reason that the GATT had ruled in the tuna dolphin case. And so the US appealed. But the WTO appellate body looked at this case in a very different way. It developed a test to determine whether the trade measure, A, concerned exhaustible natural resources, and in this case, endangered sea turtles would matter. 2, was it related to the conservation of those exhaustible natural resources? And yes, putting a new net to protect turtles versus shrimp seemed to be directly applicable. But the third is made in conjunction with restrictions on domestic production and consumption of the exhaustible natural resources. And that is sort of the key aspect to this. Was the US doing the same in its own market as opposed to other countries as well? Ultimately, the WTO appellate body did uphold the ruling, but it did so in a very different way. It differed in many respects from not only the WTO panel of experts, but also in the tuna dolphin case. And it said the US could take steps to protect sea turtles, just not in the way that it had done so. So it criticized not the objective, but the implementation of that objective. That's a very different rationale than in the tuna case, and that's much easier to fix. Here are the specific defects that the appellate body cited. That the purpose of the US law required that WTO members had to adopt turtle protection that wasn't comparable, but it had to be the exact same regulations to US fishermen. Well, the WTO said it should be comparable, not the same. The second is, if this was really about protecting turtles across the world, the US should have undertaken serious negotiations with other countries like the Indians and the Malaysians and the Pakistanis before it implemented its import ban. And there were also some due process concerns around the certification of shrimp. So the US did learn from the tuna case, had provided Caribbean countries technical and financial assistance and a longer transition period before it began using the turtle excluder devices. The problem the Americans had is they didn't do the same thing to the 4 Asian countries. And that is why the 4 Asian countries filed suit with the WTO, as they were being treated differently from the Caribbean countries. And so the WTO said that the US could not discriminate between countries by providing some of them with financial and technical assistance, but not all countries with financial and technical assistance. So the US, as with the Clean Air Act case, did comply with the ruling, and it took a number of steps to do so. It did start negotiations on how to protect turtles with all of the governments in the Indian Ocean region. It also provided financial assistance so that they could start to acquire these turtle excluder devices, and it offered technical training installation, operation of these devices to any government that requested it. So as with the Clean Air Act, they responded to the WTO ruling. This would still protect turtles, but it wasn't a form of trade protection. Nevertheless, Malaysia was still not happy, and so they filed a second suit with the WTO. But this time, the WTO and the appellate body ruled in favor of the US. They said not only were the objectives of protecting sea turtles just, but now it was being implemented in a proper way. So, what is the significance of this case? Well, critics of the WTO have said, as with the person wearing the turtle suit, that the environment always loses when it clashes with trade. But they tend to focus simply on the panel of experts' decision on shrimp and turtle, as opposed to the appellate body in the first case, and both the panel of experts and the appellate body in the second case. And if you look at those other aspects, it would show that no, the WTO does support environmental protection. It just has to be done in a proper way, in a way that doesn't discriminate against trade. Another significant aspect of the shrimp turtle case was the use of amicus curiae briefs. These are known as Friends of the Court briefs. These come from outside groups, typically social organizations. Now, this debate about who should be involved in the dispute settlement mechanism, should the companies be involved? Should social groups? Should unions? It was all defeated in the Uruguay round, which created the WTO. And instead, they said this is an international treaty. Only states that are party to the treaty should be part of the dispute settlement. Unfortunately, the expert panel in the shrimp turtle case allowed the World Wildlife Fund to submit a written brief in the case. Now, the final report said it was accepted, but they did not use that brief. But it opened the door for third-party groups to intervene into a dispute between two countries. And this has continued to be an issue within the World Trade Organization. So this concludes the second mini lecture as part of your preparation for the WTO simulation that we'll be doing later on this semester. More video lectures on different aspects of international economic policy will be forthcoming. And at this point, I will say goodbye until I meet with you again, hopefully live.